that does not have a state level ban on bump stocks. And so now here in Pennsylvania, bump stocks are, for all intents and purposes, totally legal.
What happened in Las Vegas, it is a terrifying thing to consider.
I mean, it's really a sad time for a court to make that kind of ruling. They're dead wrong, and they're dead wrong for America. I mean, I don't know what the Supreme Court's going to do. Are they now going to be the ATF? Because the country can't work that way.
Ban in U.S. post offices. The U.S. District Court for the Northern District of Texas received a federal complaint. It seeks to stop 2 statutes that prohibit bringing arms into post offices. The case claims these regulations violate the Second Amendment. The Firearms Policy Coalition, or FPC, announced the lawsuits. They were filed for Texans who say they must disarm before entering the post office but want to carry handguns for self-defense when checking their mail. The plaintiffs are all armed and want to defend themselves. One plaintiff, who often carries large amounts of cash and fears robbery, explains why they contest the regulations. Another plaintiff said he would visit the post office more often if he didn't have to disarm, especially with rising crime rates. 2 statutes are being challenged, one that forbids carrying an arm on postal property and another that forbids carrying an arm into a federal building. The plaintiffs argue that the government must prove an arm restriction is consistent with the nation's historical tradition of arm regulation, referencing the SCOTUS decision in New York State Rifle and Pistol Association versus Bruin. The Supreme Court overturned a New York ban on open carry, saying Manhattan is not a sensitive place where the ban should apply. The petition states that courts have designated the Legislative Assembly, polling stations, and courthouses as sensitive areas, but post offices do not qualify since they lack complete security. The Second Amendment guarantees the right to keep and bear arms in public places like post offices. FPC President Brandon Combs said Attorney General Garland would receive the message on time, unlike the USPS. Recent Texas federal court rulings have sided with those challenging federal arm restrictions, such as those on private transactions and pistol braces. These courts ruled that executive branch rules are unconstitutional or unenforceable because they do not comply with congressional laws. The Supreme Court is about to rule on United States versus Rahimi, its first Second Amendment case after Bruin. This case challenges a law that makes it illegal for those restraining orders to own arms.
The Supreme Court made a decision last week that he didn't like. Welcome to another day in the Democrats' summer of show votes. A 6-3 majority of the Supreme Court ruled the Bureau of Alcohol, Tobacco, Firearms, and Explosives overstepped their authority. The Supreme Court made the right decision, urging the Supreme Court to do what they did. So the majority leader has decided to bring up a bill called the Bump Act. Claims this bill will ban bump stock. The Bump Act targets common firearm accessories, not just bump stock.
The ban is unconstitutional. A Florida federal judge has ruled that a 2022 landmark U.S. Supreme Court decision expanding arm rights makes a U.S. statute prohibiting the possession of arms at post offices illegal. The decision was made by U.S. District Judge Catherine Kimball Mizell, a Republican appointee of former President Donald Trump in Tampa, when she dismissed the case against a postal worker for unlawfully possessing an arm in a federal facility. Mizell stated, a blanket restriction on arms possession in post offices is incongruent with the American tradition of arms regulation. This action infringes against Emmanuel Ayala's Second Amendment right to keep and bear arms. Separately, she refused to dismiss the accusation of resisting arrest violently. Neither the U.S. Justice Department nor Ayala's legal team returned calls seeking comment. Following the June 22 decision on New York State Rifle and Pistol Association versus Bruin by the conservative majority Supreme Court, the decision was the most recent court decision to declare an arm limitation unlawful. The right to keep and bear arms in public for self-defense was upheld in that landmark decision. A new standard for evaluating arm control measures was also laid forth, stating that limitations must be consistent with this nation's historical tradition of arm regulation. Ayala's attorneys claimed their client had a concealed weapons permit and carried a 9mm Smith & Wesson in a fanny pack for protection. After federal officials attempted to apprehend him in 2012, prosecutors said he took an arm onto Postal Service property and escaped, leading to his indictment. A federal establishment such as a post office generally prohibits holding an arm, and he was charged under this act. Mizell noted that post offices has existed since the country's inception, but it wasn't until 1964 and 1972 that federal law forbade the possession of arms in government buildings and post offices. She argued that the prohibition was unwarranted as it was based on a practice dating back to the 1700s. Allowing the federal government to prohibit visitors from bringing arms into government institutions as an admission requirement would, according to Mizell, enable it to abridge the right to bear arms by regulating it into practical non-existence.
See hope and optimism. People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year. Or a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past. Far-reaching gun law in the history of the world, it is not. But they actually did it.
If you are an irresponsible individual, you should not be allowed to carry a concealed firearm. But while we wait for them to do more to keep Californians and Americans safe, we're going to act.
ATF Pistol Brace Rule. The Firearms Policy Coalition has secured an injunction pending appeal in the Mock versus Garland case. This injunction delays the implementation of the ATF Pistol Brace Rule, which was set to go into effect on May 1. The court granted the appellant's motion for a preliminary injunction pending appeal, and the FPC Action Foundation is pleased with the decision. They plan to ask the court for more details about who is covered under the injunction. The new ATF Pistol Brace Rule applies to almost all arms equipped with stabilizing braces, including AR pistols and non-NFA arms like the Mossberg Shockwave. These arms have not been outright banned but are reclassified as short-barreled rifles or SBRs or short-barreled shotguns or SBS if a brace is attached. The federal grace period was set to end on May 31. Armed rights activists, including members of Congress, believe the ATF has overstepped its bounds.
It does not have a state-level ban on bump stocks, and so now here in Pennsylvania, bump stocks are, for all intents and purposes, totally legal.
What happened in Las Vegas, it is a terrifying thing to consider the great evil that can be committed by one of these, practicality, a machine gun on the street. So it is something that is scary.
I mean, it's really a sad time for a court to make that kind of ruling. They're dead wrong, and they're dead wrong for America.
House Republicans, along with Senators John Kennedy and Roger Marshall, introduced resolutions to repeal the ATF Pistol Brace Rule. However, it is unlikely these resolutions will pass in time to stop the rule from taking effect. The new rule means the ATF will consider pistol braces as stocks. Any arm with a brace installed will be subject to the same rules under the National Firearms Act or NFA. The ATF began prohibiting the sale of braced pistols on January 31, 2023.
For the Senate to consider my legislation, the Banning Unlawful Machine Gun Parts or BUMP Act. More than 20,000 people gathered for a large outdoor music festival. No one could have anticipated the nightmare that was about to unfold then. Then over the music, they started to hear what at first people thought were fireworks. Complete panic erupted. Rapid gunfire rained down on the crowd with shots so close together that they seemed to almost bleed into each other. Concert goers ran in every direction, searching for cover where there was none.
Individuals, dealers, and government entities possessing these arms were given 120 days to comply in one of 5 ways: declaring the arm as a short-barreled rifle or SBR under the National Firearms Act or NFA, converting the pistol to a rifle by replacing the short barrel with one that is 16 inches or long, permanently removing and disposing of or altering the stabilizing brace, forfeiting the arm to a local ATF office, or destroying the arm. The penalty for non-compliance is severe: a fine of up to $10,000, 10 years in prison, or both. The ATF has issued conflicting information about whether removing a brace from an arm is enough to comply with the new rule. Newer statements indicate that owners must also dispose of or destroy the brace. The message seems to be save the braces if you want, but if we catch you, charging you with a crime will be a game time decision. Some arm owners do not trust the free registration option. Many chose to register their braced pistols as SBRs during the grace period. However, Steve Doolin, second vice chair and legal foundation chair for the Michigan Coalition of Responsible Arm Owners, is against the registration option. He believes the rule will be invalidated due to the ATF's overreach and inconsistent past rulings. The ATF has announced a new pistol brace rule requiring arm owners to register their arms in short-barreled rifle or SBR configurations. The rule, which takes effect upon publication in the Federal Register, requires manufacturers, dealers, and individuals to comply with laws regulating these rifles, including the National Firearms Act, or NFA. The rule aims to prevent braces from being used to circumvent the NFA, affecting millions of braces in circulation. The rule allows a 120-day period for manufacturers, dealers, or individuals to register any existing NFA short-barreled rifles covered by the rule with the normal SBR tax waived. If owners do not want to register, they can remove the brace to return the arm to a pistol or surrender the arm to the ATF. The ATF has posted a web page explaining the rule and issued instructions on how to comply, including 2 lists of brace arms that the ATF now considers SBRs. The new brace scorecard is based on the now shelved ATF Worksheet 4999, which may provide insight into what all arms on the list have in common. That's all for this video, folks. See you next time.